Minnesota Real Estate Exam 2026. Question 1. If annual property taxes of $3,700 are prorated to the seller for 157 days on a 365-day basis, approximately what amount is charged to the seller? Option A, $1,592. Option B, $18,480. Option C, $4,032. Option D, $1,232. The correct answer is option A, $1,592. Tax proration divides the annual tax by 365 and multiplies by the number of seller days. Commission, discount points, and monthly interest are unrelated calculations. Proration allocates an annual expense fairly between buyer and seller at closing. Question 2. Under Chapter 82 Standards, what must a broker do to properly supervise salespersons at a Moorhead office? Option A. Let each salesperson approve their own contracts without broker review. Option B. Monitor brokerage activities, review transaction documents, and review trust account books and records. Option C. Delegate all trust records to buyers and sellers. Option D. Supervise only advertising and ignore purchase agreements. The correct answer is option B. Monitor brokerage activities, review transaction documents, and review trust account books and records. Broker supervision includes ongoing monitoring of salespersons, transaction documents, and trust account records. Salespersons do not self-supervise, and clients are not responsible for brokerage trust accounting. Limiting supervision to advertising would miss major broker responsibilities. Question 3. If a broker provides the predatory offender registry notice in a timely manner, what is generally true about offender registry information for Parker in Rochester involving a newly built townhouse priced at $408,500? Option A. The broker must personally investigate every nearby resident. Option B. The broker must guarantee no offenders live in the city. Option C. The broker has no duty to disclose specific registry information beyond the required notice. Option D. The broker must cancel the purchase agreement automatically. The correct answer is option C. The broker has no duty to disclose specific registry information beyond the required notice. Minnesota disclosure law limits a licensee's duty regarding registry information when the required notice is provided. The broker does not guarantee neighborhood conditions or act as law enforcement. Automatic contract cancellation is not the disclosure rule. Question 4. After passing the examination, Harper wants to submit a Minnesota salesperson license application immediately. Which education requirement still must be met before applying? Option A. Only course I is ever required for the license. Option B. A broker's 30-hour course must replace course 3. Option C. No additional education is needed once the exam is passed. Option D. Courses 2 and 3 must be successfully completed if they have not already been completed. The correct answer is option D. Courses 2 and 3 must be successfully completed if they have not already been completed. Course I opens exam eligibility, but courses 2 and 3 must be completed before the salesperson license application. Passing the exam does not erase the remaining pre-license education requirement. The other options either omit required courses or invent a broker-only replacement course. Question 5. A Minnesota salesperson renewal fee includes a contribution to which fund for Quinn in Duluth involving a farm parcel priced at $443,000? Option A. Real Estate Education, Research and Recovery Fund. Option B. Federal Flood Insurance Reserve. Option C. County Recording Technology Fund only. Option D. Private MLS Scholarship Account. The correct answer is option A. Real Estate Education, Research and Recovery Fund. Minnesota salesperson license fees include an amount for the Real Estate Education, Research and Recovery Fund. Flood insurance reserves, county recording funds, and private MLS accounts are unrelated. The fund is part of the state licensing fee structure. Question 6. An older commercial building in Moorhead may contain asbestos insulation. What should the licensee avoid doing? Option A. Recommending qualified inspection or environmental advice. Option B, giving a technical safety opinion beyond the licensee's expertise. Option C, disclosing known material facts. Option D, using written reports from qualified professionals. The correct answer is option B, giving a technical safety opinion beyond the licensee's expertise. Asbestos concerns should be handled with qualified inspection and proper disclosure of known material facts. A licensee should avoid technical safety opinions outside the real estate role. Professional reports and disclosure are safer than speculation. Question 7. During a Bemidji license renewal review, which continuing education schedule best matches Minnesota salesperson requirements? Option A, 10 hours every 4 years with no annual deadline. Option B, 30 hours only during the first licensing year. Option C, 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. Option D, only the required module with no other continuing education. The correct answer is option C, 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. Minnesota salespersons generally need 30 hours of continuing education before the June 30th renewal deadline, with at least 15 hours due before the previous June 30th. The other options understate the hours, remove the annual structure, or treat the module as the only requirement. Continuing education must be completed in the proper license period. Question 8. A buyer asks whether a nursing home in the neighborhood must be disclosed as a material fact. How does Minnesota treat that issue for Cameron in Moorhead involving a fourplex priced at $291,000? Option A. It is always a material defect in the property. Option B. It requires a separate appraisal license. Option C. It makes the deed void. Option D. The location of a nursing home nearby is not a material fact that must be disclosed merely for that reason. The correct answer is option D. The location of a nursing home nearby is not a material fact that must be disclosed merely for that reason. Minnesota law excludes certain neighborhood-related facilities, including nursing homes, from material fact treatment merely because they are nearby. This does not remove duties to disclose physical defects or known material facts. Appraisal licensing and deed validity are unrelated. Question 9. Before Skylar schedules the salesperson examination after studying in Egan, which pre-license course must already be completed? Option A, Course I. Option B, Course 2 only. Option C, Course 3 only. Option D, the annual continuing education module. The correct answer is option A, Course I. Course I must be successfully completed before a candidate registers for the salesperson examination. Course 2 and Course 3 are required before license application, while the annual module is a continuing education requirement for licensees. Confusing pre-license and continuing education rules leads to the wrong result. Question 10. Recording a deed for a vacant lot in Winona County primarily gives what type of notice to the public? Option A, private notice only to the buyer's lender. Option B, constructive notice. Option C, a zoning variance. Option D, a guarantee of physical condition. The correct answer is option B, constructive notice. Recording places an instrument in the public records and gives constructive notice of the recorded interest. It does not create a zoning variance or guarantee the property's physical condition. The public records system protects priority and notice, not building quality. Question 11. In a lien theory mortgage state such as Minnesota, what does the mortgage usually give the lender for Parker in Rochester involving a townhome priced at $449,500? Option A, immediate ownership and possession of the property. Option B, a life estate measured by the borrower's life. Option C, a lien securing repayment while the borrower retains title. Option D, a leasehold estate for the loan term. The correct answer is option C, a lien securing repayment while the borrower retains title. In lien theory, the mortgage gives the lender a security lien rather than immediate title and possession. The borrower retains legal title unless foreclosure changes ownership. Life estates and leaseholds are different interests, not the ordinary mortgage relationship. Question 12. If one broker represents both Kendall Patel and Emerson Khan in a residential transaction, what must occur before the broker acts as a dual agent? Option A. Only the seller must consent because the seller listed the property. Option B. The broker may proceed without consent if the commission is reduced. Option C. Consent is unnecessary if two different salespersons are involved. Option D. All parties must give informed consent to the dual agency relationship. The correct answer is option D. All parties must give informed consent to the dual agency relationship. Dual agency requires informed consent from the parties because the broker owes duties to both sides and cannot advocate exclusively for either one. A lower commission does not remove the conflict, and two salespersons licensed to the same broker can still create dual agency. Seller-only consent is not enough. Question 13. While interviewing with two firms in Brainerd, Morgan asks how many Minnesota brokers may supervise the salesperson during the same period. Option A. One actively licensed broker. Option B. Two brokers if both brokers consent. Option C. Any number of brokers if the salesperson discloses the arrangement. Option D. One broker for residential sales and a separate broker for leases. The correct answer is option A. One actively licensed broker. A salesperson in Minnesota is licensed to act on behalf of one broker during the same period. Consent or disclosure does not create authority to work under multiple brokers. Splitting residential and leasing work between brokers would still violate the Single Broker Association rule. Question 14. A buried heating oil tank is discovered during inspection of a vacant lot. Why is this important? Option A. They automatically convert the property to personal property. Option B. Underground storage tanks can create environmental and cleanup concerns that may affect value and use. Option C. They prove the deed is forged. Option D. They eliminate all mortgage requirements. The correct answer is option B. Underground storage tanks can create environmental and cleanup concerns that may affect value and use. Underground storage tanks may involve leaks, regulatory requirements, and cleanup costs, making them material environmental concerns. They do not convert real estate into personal property, prove deed fraud, or remove financing requirements. Environmental issues can affect value, marketability, and buyer decisions. Question 15. A buyer asks about radon during a Blaine home purchase. What is the safest professional response for a licensee for Morgan & Blaine involving a newly built townhouse priced at $413,500? Option A. Guarantee that radon is never a concern in Minnesota. Option B. Tell the buyer to ignore radon because it is a title defect. Option C. Provide required or available radon information and recommend appropriate testing or qualified advice rather than guaranteeing levels. Option D. Prepare a scientific certification without testing. The correct answer is option C. Provide required or available radon information and recommend appropriate testing or qualified advice rather than guaranteeing levels. Radon is an environmental concern that should be addressed with required information, testing, and qualified resources. A licensee should not guarantee levels or provide scientific certification without proper expertise. Radon is a physical/environmental issue, not a title defect. Question 16. A deed expressly creates survivorship between co-owners of a newly built townhouse. Which ownership feature is being emphasized for Morgan & Blaine involving a newly built townhouse priced at $412,500? Option A. No right to possess the property. Option B. A tenant's trade fixture right. Option C. A mortgagee's foreclosure priority. Option D. Right of survivorship in joint tenancy. The correct answer is option D. Right of survivorship in joint tenancy. Joint tenancy is associated with right of survivorship when properly created. Co-owners generally have possession rights, and trade fixtures concern tenants rather than co-owner succession. Mortgage priority is a lien issue, not survivorship ownership. Question 17. Which Minnesota tax is generally associated with recording a deed that conveys real property for Hayden and Egan involving a townhome priced at $338,500? Option A. State deed tax. Option B, mortgage registry tax only. Option C, utility franchise fee. Option D, federal gift tax return fee. The correct answer is option A, state deed tax. Deed tax is generally associated with recording a deed conveying real property. Mortgage registry tax relates to mortgage debt, while utility franchise and federal gift tax issues are outside the ordinary deed recording charge. The transaction document determines which tax applies. Question 18. During a first substantive contact with a residential consumer in Bloomington, what disclosure should the licensee provide? Option A, a final closing disclosure showing loan terms. Option B, an agency disclosure form explaining available agency and facilitator relationships. Option C, a county tax statement for the current year. Option D, a deed prepared for recording. The correct answer is option B, an agency disclosure form explaining available agency and facilitator relationships. Minnesota requires an agency disclosure form at the first substantive contact in residential transactions covered by the statute. The form explains representation choices and facilitator status before the consumer decides whether to enter a representation contract. Closing disclosures, tax statements, and deeds serve different functions later in the transaction. Question 19. A seller instructs the licensee not to disclose a known structural defect to buyers. Which principal controls for Reese in Mankato involving a mixed-use property priced at $330,500? Option A, the licensee must obey every instruction from a client. Option B, the defect becomes confidential forever. Option C, the licensee cannot obey unlawful instructions that conflict with required disclosure duties. Option D, the buyer's broker alone must discover every defect. The correct answer is option C. The licensee cannot obey unlawful instructions that conflict with required disclosure duties. Obedience applies only to lawful instructions. A client cannot require a licensee to hide a material fact that law requires to be disclosed. The duty to disclose known material defects is not shifted entirely to the buyer's broker. Question 20. A landlord receives a forwarding address after a tenant leaves a Minnesota rental. What deadline is commonly tested for returning the deposit or giving a written explanation for Quinn in Duluth involving a condominium unit priced at $344,000? Option A, within 1 year after the lease began. Option B, only at the next property tax settlement. Option C, whenever the landlord sells the building. Option D, within 21 days after the tenancy ends, assuming the forwarding address requirement is met. The correct answer is option D, within 21 days after the tenancy ends, assuming the forwarding address requirement is met. Minnesota landlord-tenant materials commonly test the 21-day security deposit return or explanation period after the tenancy ends and the forwarding address is provided. Waiting for a tax settlement, building sale, or 1-year mark does not match the standard rule. The landlord must account for the deposit promptly. Question 21. A garage built on Morgan Garcia's land extends 2 feet over the boundary onto a neighbor's parcel. What issue is created? Option A, encroachment. Option B, hypothecation. Option C is subrogation. Option D, reconciliation. The correct answer is option A, encroachment. An encroachment occurs when an improvement physically intrudes onto another parcel. Hypothecation pledges property for debt. Subrogation substitutes one party's claim, and reconciliation is an appraisal conclusion step. The garage crossing the boundary is the key fact. Question 22. At the end of a Minnesota tenancy, what must a landlord generally do with the tenant's security deposit after receiving a forwarding address for Finley and Stillwater involving a farm parcel priced at $298,500? Option A, keep the entire deposit automatically as a cleaning fee. Option B, return the deposit plus interest or provide a written explanation of lawful deductions within the required time. Option C, apply the deposit to the broker's commission. Option D, record the deposit with the county as a deed restriction. The correct answer is option B, Return the deposit plus interest or provide a written explanation of lawful deductions within the required time. Minnesota law requires the landlord to return the deposit with interest or provide a written explanation for lawful deductions within the required period. Automatic forfeiture, commission payment, and county deed restrictions do not match the security deposit rules. Security deposits remain tenant funds unless a lawful deduction applies. Question 23. If an override clause appears in Taylor Davis's listing agreement, what must the licensee provide within 72 hours after the listing expires for the clause to be effective? Option A. A new deed. Option B. A county tax appeal. Option C. A protective list. Option D. A mortgage payoff statement. The correct answer is option C. A protective list. An override clause is tied to a protective list supplied within the required time after expiration. A deed, tax appeal, or payoff statement does not preserve the broker's override rights. The protective list identifies prospects covered by the clause. Question 24. A buyer pays 1.5% in discount points on a $216,800 loan. Approximately how much are the points? Option A, $1,265. Option B, $54,200. Option C, $17,615. Option D, $3,252. The correct answer is option D, $3,252. One discount point equals 1% of the loan amount, so the points are calculated by multiplying the loan amount by the point percentage. Monthly interest, down payment, and commission are calculated from different formulas. The point charge is a loan cost calculation, not a sales commission or equity contribution. Question 25. A buyer representation agreement in Moorhead is best described as what type of document? Option A. A written contract that creates agency representation for the buyer. Option B. A deed transferring title to the buyer. Option C. A loan commitment from the lender. Option D. A property tax statement from the county. The correct answer is option A. A written contract that creates agency representation for the buyer. A buyer representation agreement is the written contract that creates buyer agency. It does not transfer title, approve financing, or state county taxes. Representation contracts define the broker-client relationship and compensation terms. Question 26. If Kendall Peterson tells the licensee that the seller will not perform under the signed purchase agreement, what must the licensee do? Option A. Keep the information confidential until the closing date. Option B. Immediately disclose the stated intent not to perform to the other party or parties. Option C. Cancel the agreement without telling the buyer. Option D. Disclose only if the seller misses a loan contingency. The correct answer is option B. Immediately disclose the stated intent not to perform to the other party or parties. A licensee put on notice that a party will not perform according to the transaction agreement must disclose that intent to the other party or parties. Keeping the information secret would mislead the other side. The rule is different from a party's inability to satisfy a contingency. Question 27. A buyer includes an inspection condition in a Winona purchase agreement. What is the role of that contingency? Option A. It automatically transfers title to the buyer. Option B. It eliminates the need for earnest money accounting. Option C. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. Option D. It makes the broker a home inspector. The correct answer is option C. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. A contingency is a condition that must be satisfied, waived, or otherwise resolved for the contract obligations to proceed as written. It does not transfer title or remove trust accounting duties. The broker does not become the inspector merely because the contract contains an inspection contingency. Question 28. A landlord in Blaine deducts from a security deposit for unpaid rent and damage beyond ordinary wear and tear. What makes those deductions more defensible for Morgan and Blaine involving a townhome priced at $440,000? Option A. They are based only on the landlord's dislike of the tenant. Option B. They include normal fading of paint from ordinary use. Option C. They are taken without notice because deposits are always non-refundable. Option D. They are tied to permitted reasons and supported by a written explanation. The correct answer is option D. They are tied to permitted reasons and supported by a written explanation. Minnesota security deposit deductions are generally tied to unpaid obligations or damage beyond ordinary wear and tear, with a written explanation when money is withheld. Personal dislike, normal wear, and treating every deposit as non-refundable are not defensible bases. Documentation is essential in landlord-tenant accounting. Question 29. A buyer deposits earnest money with a broker in the form of a negotiable note rather than cash. What extra care is needed for Quinn in Duluth involving a condominium unit priced at $266,000? Option A. The non-depositable item must be handled through authorized escrow with written authority and proper records. Option B. The broker may throw it away because it is not cash. Option C. It can be placed in the broker's personal safe without records. Option D. It automatically becomes commission income. The correct answer is option A. The non-depositable item must be handled through authorized escrow with written authority and proper records. Non-depositable items received as earnest money require careful escrow handling, written authority when the broker holds them, and proper records. They are not discarded, hidden as personal property, or treated as commission income. The rule protects all parties' interests in non-cash deposits. Question 30. Why might BlairCon use a quitclaim deed to clear a possible title issue? Option A. It guarantees the property is free of every lien. Option B. It transfers whatever interest the grantor may have without making title warranties. Option C. It creates a new mortgage automatically. Option D. It replaces the need for delivery and acceptance. The correct answer is option B. It transfers whatever interest the grantor may have without making title warranties. A quitclaim deed can release or transfer any interest the grantor may have, but it does not warrant title quality. It does not guarantee lien-free ownership or create a mortgage. Like other deeds, it still depends on proper execution, delivery, and acceptance. Question 31. A lender draws a line around a Hennepin neighborhood and refuses otherwise qualified mortgage applicants there. What fair housing and lending term best fits? Option A. Plottage. Option B. Accretion. Option C. Redlining. Option D. Estoppel. The correct answer is option C. Redlining. Redlining is denying or limiting credit in an area for discriminatory reasons rather than evaluating individual qualifications. Plottage relates to value from assemblage, accretion is natural land buildup, and estoppel prevents inconsistent claims. Area-based discriminatory lending violates fair lending principles. Question 32. If Cameron fails to complete required continuing education by the renewal deadline, what license consequence can occur? Option A. The license automatically converts to a broker license. Option B. The license becomes a deed restriction. Option C. The license renews for free without further action. Option D. The license can become inactive. The correct answer is option D. The license can become inactive. Failure to complete continuing education before the deadline can cause a Minnesota real estate license to become inactive. It does not upgrade the license, affect title to property, or waive renewal obligations. Continuing education is a condition of maintaining active status. Question 33. A rumor says a Northfield home was once the site of a natural death and possible paranormal activity. Under Minnesota disclosure rules, how is that fact treated? Option A. It is not treated as a material fact that must be disclosed merely for that reason. Option B. It must always be disclosed in the listing contract. Option C. It makes the property unmarketable until court approval. Option D. It requires the buyer to receive a separate environmental report. The correct answer is option A. It is not treated as a material fact that must be disclosed merely for that reason. Minnesota law states that certain stigmatizing facts, such as suicide, natural death, or perceived paranormal activity, are not material facts requiring disclosure merely because they occurred. That does not change the duty to disclose physical defects or other material facts. Listing contracts, court approval, and environmental reports address different issues. Question 34. A social media ad for a newly built townhouse in Winona uses a team name. What must the advertisement clearly and conspicuously display? Option A. Only the salesperson's nickname. Option B. The real estate brokerage name. Option C. Only the property street address. Option D. Only the team logo without the brokerage. The correct answer is option B. The real estate brokerage name. Minnesota advertising rules require the brokerage name to be clearly and conspicuously displayed. A team name may be used only with broker authorization, and the brokerage name still must appear. Nicknames, street addresses, and logos do not replace the required brokerage identification. Question 35. A borrower gives a mortgage on a Rochester property while retaining possession. What financing concept lets the borrower pledge the property without surrendering it? Option A. Avulsion. Option B. Emblements. Option C. Hypothecation. Option D. Accession. The correct answer is option C. Hypothecation. Hypothecation means pledging property as security for a debt while retaining possession. Avulsion and accession concern land or property changes, while emblements are crops. Mortgage lending commonly uses hypothecation. Question 36. Which fiduciary duty requires a broker to keep client money and property properly accounted for Morgan & Blaine involving a newly built townhouse priced at $418,500? Option A. Assemblage. Option B. Accretion. Option C. Divulsion. Option D. Accounting. The correct answer is option D. Accounting. Accounting requires a broker to account for money and property received on behalf of a client. Assemblage, accretion, and avulsion are property or land concepts, not fiduciary duties. The key clue is handling client property and funds. Question 37. Under Minnesota licensing rules, what happens when a salesperson's association with an actively licensed broker ends for Reese in Mankato involving a mixed-use property priced at $405,000? Option A. The salesperson's license becomes inactive until proper association is restored. Option B. The salesperson may continue independently for 90 days. Option C. The salesperson automatically becomes a limited broker. Option D. The salesperson may transfer clients without broker supervision. The correct answer is option A. The salesperson's license becomes inactive until proper association is restored. A salesperson license depends on active association with a licensed broker. Ending that association makes the license inactive, so independent practice is not allowed. Automatic broker status and unsupervised client transfers are not part of the salesperson licensing structure. Question 38. A retail tenant pays base rent plus a percentage of monthly sales. What lease type is described for Casey and Eden Prairie involving a vacant lot priced at $271,000? Option A. Ground lease only. Option B. Percentage lease. Option C. Graduated deed. Option D. Quitclaim lease. The correct answer is option B. Percentage lease. A percentage lease includes rent based partly on the tenant's sales, commonly in retail settings. A ground lease involves leasing land, and the other terms are not standard lease classifications. The sales volume rent formula is the key clue. Question 39. A buyer receives a qualified third-party inspection report, but the licensee knows a fact that contradicts it. What must the licensee do for Casey and Eden Prairie involving a farm parcel priced at $214,500? Option A. Stay silent because the report always controls. Option B. Destroy the report and order a new one. Option C. Disclose known facts that contradict the report. Option D. Tell only the inspector after closing. The correct answer is option C. Disclose known facts that contradict the report. A licensee may rely on a qualified third-party report unless the licensee knows facts that contradict it. Known contradictions must be disclosed to the parties. Silence, destruction of the report, or delayed notice would undermine the disclosure duty. Question 40. A tenant remains in possession after a lease expires without the landlord's consent. What is the tenant's status for Casey and Eden Prairie involving a vacant lot priced at $383,000? Option A, remainderman. Option B, joint tenant. Option C, dominant tenant. Option D, tenant at sufferance. The correct answer is option D, tenant at sufferance. A tenant at sufferance is a holdover who originally had lawful possession but stays without consent after the right ends. A remainderman holds a future interest, a joint tenant is a co-owner, and dominant tenant is not the standard term. The holdover fact controls. Question 41. Wetlands are suspected on a vacant St. Louis County parcel. What should a licensee recommend before development assumptions are made? Option A, obtain qualified advice about wetland restrictions and permitting. Option B, assume all wetlands can be filled without approval. Option C, use only the buyer's preferred building sketch. Option D, ignore wetlands because they affect only personal property. The correct answer is option A, obtain qualified advice about wetland restrictions and permitting. Wetland restrictions can limit development and require permits or expert review. Assuming fill is allowed or relying only on a sketch creates risk. Wetlands are real property and land use issues, not merely personal property concerns. Question 42. A contract substitutes a new party and releases the original party from liability. Which term best describes that change for Drew and Adina involving a single-family home priced at $317,500? Option A, assignment only. Option B, novation. Option C, accretion. Option D, hypothecation. The correct answer is option B, novation. Novation substitutes a new obligation or party and releases the original party when all required parties agree. Assignment transfers rights but does not necessarily release the assignor. Accretion and hypothecation involve land buildup and pledging property as security. Question 43. A broker learns that a foundation defect could significantly affect Riley Miller's use of a lake cabin in Red Wing. What should the broker do? Option A, stay silent because the defect might reduce the seller's price. Option B, disclose only after closing if the buyer complains. Option C, disclose the material fact to the prospective purchaser. Option D, treat the defect as confidential even if it affects use and enjoyment. The correct answer is option C, disclose the material fact to the prospective purchaser. Known material facts that could adversely and significantly affect an ordinary buyer's use or enjoyment must be disclosed. Protecting a sale price does not excuse non-disclosure, and waiting until after closing defeats the purpose of the rule. Confidentiality does not cover facts that law requires to be disclosed. Question 44. A listing agreement for a Maple Grove seller is missing a definite end date. Why is that a licensing problem? Option A, listing agreements are valid only if they renew forever. Option B, expiration dates are allowed only in commercial leases. Option C, the county recorder assigns the expiration date after closing. Option D, Minnesota listing agreements must include a definite expiration date. The correct answer is option D. Minnesota listing agreements must include a definite expiration date. Minnesota listing agreements must be written and include a definite expiration date. Automatic indefinite listings create consumer protection concerns and do not meet the required content rules. County recorders do not supply listing agreement expiration dates. Question 45. When Skylar Peterson buys a condominium unit in Eagan, what does the buyer typically own? Option A, the individual unit plus an undivided interest in the common elements. Option B, only a stock certificate and no real property interest. Option C, the entire building in severalty. Option D, a temporary license to occupy the unit. The correct answer is option A, the individual unit plus an undivided interest in the common elements. Condominium ownership generally includes the individual unit and an undivided interest in common elements. A cooperative usually involves shares and a proprietary lease, not condominium ownership. The buyer does not own the whole building alone or merely hold a temporary license. Question 46. Why would an appraiser rely heavily on the cost approach for a newly built small retail building in Eagan? Option A. It ignores land value completely. Option B. Replacement cost and depreciation can be estimated more reliably for new improvements. Option C. It is the only legal method for all residential property. Option D. It values the property only by monthly rent. The correct answer is option B. Replacement cost and depreciation can be estimated more reliably for new improvements. The cost approach is useful for new construction because replacement cost and accrued depreciation can be estimated with less uncertainty. It still includes land value and is not the only legal method for every property. Monthly rent belongs to income analysis rather than cost analysis. Question 47. In a gross lease for a still water office, which cost structure is most typical? Option A. The tenant pays all property taxes, insurance, and maintenance separately. Option B. The tenant receives title at the end of the lease. Option C. The landlord pays most property operating expenses from the rent received. Option D. The rent is based only on retail sales volume. The correct answer is option C. The landlord pays most property operating expenses from the rent received. In a gross lease, the landlord typically pays most operating expenses and receives rent as a gross amount. Net leases shift more expenses to the tenant, and percentage leases tie rent partly to sales. A lease does not transfer title merely because it is gross. Question 48. A loan payment schedule gradually reduces principal until the loan balance reaches zero. What financing term describes this for Quinn in Duluth involving a vacant lot priced at $334,000? Option A. Accretion. Option B. Subordination. Option C. This cheat. Option D. Amortization. The correct answer is option D. Amortization. Amortization is repayment of a debt through payments that reduce principal over time. Accretion is natural land buildup. Subordination changes lien priority, and escheat transfers property to the state when no heirs exist. The decreasing loan balance is the clue. Question 49. A Edina parcel contains 1 acres. How many square feet are in the parcel? Option A. 43,560. Option B. $19,200. Option C. $329,000. Option D. $4,512. The correct answer is option A. 43,560. 1 acre contains 43,560 square feet, so acreage is converted by multiplying acres by 43,560. Frontage value, loan amount, and tax amount are calculated from different data. Unit conversion is a common real estate math task. Question 50. A mortgage contains a clause allowing the lender to call the full balance due after default. What clause is this for Avery in St. Paul involving a fourplex priced at $418,500? Option A. Habendum clause. Option B. Acceleration clause. Option C. Quiet enjoyment clause. Option D. Substitution clause in appraisal. The correct answer is option B. Acceleration clause. An acceleration clause allows the lender to demand the entire debt after default. A habendum clause is associated with deeds, quiet enjoyment appears in leases, and substitution in appraisal is a valuation principle. The trigger is borrower default. Question 51. At closing, why are prepaid property taxes or rents commonly prorated between buyer and seller for Morgan & Blaine involving a newly built townhouse priced at $375,000? Option A. To change the sales price after acceptance. Option B. To avoid recording the deed. Option C. To allocate income or expenses to the party who owned the property during the relevant time period. Option D. To eliminate the need for title insurance. The correct answer is option C. To allocate income or expenses to the party who owned the property during the relevant time period. Priorations allocate recurring income and expenses based on the period each party is entitled to or responsible for them. They do not rewrite the price, avoid recording, or replace title insurance. Closing statements use debits and credits to make this allocation. Question 52. In Winona, a new applicant asks which combination best describes the salesperson licensing path in Minnesota for Skylar in Winona involving a townhome priced at $336,000. Option A. Be at least 21, complete only course I, and work independently after passing the exam. Option B. Complete continuing education before any pre-license education and apply directly without a broker. Option C. Pass only the national exam and begin practicing while the application is pending. Option D. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. The correct answer is option D. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Minnesota salesperson licensing requires age eligibility, 3 30-hour pre-license courses, examination success, broker association, and approval by the Commerce Department. The other choices either remove required courses, allow independent practice, or treat a pending application as authority to act. Those alternatives do not satisfy the licensing sequence. Question 53. An easement benefits a neighboring parcel by allowing driveway access across Cameron Johnson's land. What type of easement is most likely? Option A. Easement appurtenant. Option B. Personal license only. Option C. Trade fixture. Option D. A mechanic's lien. The correct answer is option A. Easement appurtenant. An easement appurtenant benefits another parcel and usually runs with the land. A personal license is revocable permission, a trade fixture is tenant property, and a mechanic's lien secures payment for improvements. The presence of a benefited parcel points to an appurtenant easement. Question 54. A Winona salesperson wants to place personal money in the broker trust account to save for taxes. Why is that improper? Option A. Personal funds must always be kept in the listing broker's trust account. Option B. Trust accounts may contain only trust funds except limited identified funds for service charges or minimum balance requirements. Option C. Salespersons may use trust accounts as savings accounts with broker consent. Option D. Commingling is allowed when the amount is less than 1 month's rent. The correct answer is option B. Trust accounts may contain only trust funds except limited identified funds for service charges or minimum balance requirements. Trust accounts are for trust funds, with only limited identified personal funds allowed for service charges or minimum balance requirements. Using the account as a personal savings account would commingle funds. Broker consent or a small amount does not change the commingling rule. Question 55. If a Winona property sells for $434,000 and the buyer obtains a 90% loan, what is the buyer's down payment? Option A. $390,600. Option B. $30,380. Option C. $43,400. Option D. $506. The correct answer is option C. $43,400. The down payment is the sale price minus the loan amount. The loan amount is the financed portion, the commission is a brokerage compensation calculation, and the tax proration allocates property taxes. Separating buyer equity from loan proceeds is a core exam math skill. Question 56. For a pre-1978 residential property, what federal disclosure issue should a licensee remember for Morgan and Blaine involving a townhome priced at $305,000? Option A. The property can never be sold. Option B. Only commercial buyers receive the pamphlet. Option C. Lead disclosure replaces all agency disclosure. Option D. Lead-based paint disclosure requirements may apply before the buyer or tenant is obligated. The correct answer is option D. Lead-based paint disclosure requirements may apply before the buyer or tenant is obligated. Federal lead-based paint rules apply to many pre-1978 residential transactions and require disclosure before the buyer or tenant is obligated. The rules do not ban every sale or limit disclosure to commercial buyers. Lead disclosure is separate from agency disclosure and material fact duties. Question 57. A seller says the basement is perfectly dry despite knowing of repeated water intrusion. Why is that more than ordinary puffing for Kendall in Brainerd involving a newly built townhouse priced at $288,500? Option A. It is a factual misrepresentation about a material property condition. Option B. It is always protected opinion regardless of knowledge. Option C. It is allowed if the buyer gets a loan. Option D. It becomes legal if stated verbally instead of in writing. The correct answer is option A. It is a factual misrepresentation about a material property condition. A specific false statement about a known material condition can be misrepresentation. Puffing is general opinion, not a false factual claim about water problems. Financing approval or verbal delivery does not make a known material misstatement acceptable. Question 58. If a seller rejects Rowan Garcia's offer and the listing broker holds the earnest money, when should the rejected offer's earnest money be returned? Option A. Only after the seller signs a different purchase agreement. Option B. No later than the next business day after rejection. Option C. At the end of the listing period. Option D. After the broker deducts marketing expenses. The correct answer is option B. No later than the next business day after rejection. When an offer is rejected, Minnesota trust account rules require earnest money to be returned to the potential buyer no later than the next business day after rejection. The broker cannot hold it until another sale, listing expiration, or reimbursement of marketing costs. Rejected offers do not create a right to keep the buyer's funds. Question 59. A salesperson tells owners in St. Paul to sell quickly because people from a protected class are moving nearby. What prohibited practice does this describe? Option A. Reconciliation. Option B. Hypothecation. Option C. Blockbusting. Option D. Assemblage. The correct answer is option C. Blockbusting. Blockbusting uses fear or panic about protected class changes to induce owners to sell or rent. Reconciliation is an appraisal step, hypothecation pledges property as loan security, and assemblage combines parcels. The key issue is discriminatory pressure on owners. Question 60. A rental property produces $37,500 in net operating income and investors require a 6.5% capitalization rate. What value is indicated by the income approach? Option A. $169,625. Option B. $371,600. Option C. $31,350. Option D. $576,923. The correct answer is option D. $576,923. The income approach using direct capitalization divides net operating income by the capitalization rate. Gross rent multiplier, loan amount, and frontage calculations use different inputs. The cap rate converts expected net income into an indicated value. Question 61. A tenant with a disability asks for an assigned accessible parking space near the entrance. What fair housing concept is most directly involved for Taylor in Northfield involving a duplex priced at $373,000? Option A. Reasonable accommodation. Option B. Adverse possession. Option C. Yield spread premium. Option D. Defeasance clause. The correct answer is option A. Reasonable accommodation. A reasonable accommodation is a change in rules, policies, or services that may be needed for a person with a disability to use and enjoy housing. Adverse possession concerns ownership claims, yield spread premiums concern loan compensation, and defeasance clauses concern loan satisfaction. The requested parking change involves access to housing. Question 62. Two investors own a Edina duplex with unequal shares and no survivorship language. Which ownership form is most likely? Option A. Tenancy by the entirety. Option B. Tenancy in common. Option C. Severalty. Option D. Life tenancy only. The correct answer is option B. Tenancy in common. Tenancy in common allows unequal ownership shares and has no automatic right of survivorship. Severalty means one owner, and a life tenancy is measured by a life. Tenancy by the entirety is a special marital form not described by unequal investor shares. Question 63. Which fiduciary duty requires a broker to follow a client's lawful directions for Hayden and Egan involving a townhome priced at $335,000? Option A is cheat. Option B, novation. Option C, obedience. Option D, subordination. The correct answer is option C, obedience. Obedience requires following lawful client instructions. It does not require obeying illegal instructions or ignoring disclosure duties. Is cheat, novation, and subordination are unrelated legal concepts. Question 64. Before advertising Kendall Okafor's vacant lot to the general public, what must a Minnesota licensee obtain? Option A. An oral promise that the owner may list later. Option B. A buyer's pre-approval letter. Option C. A tax parcel map from the county. Option D. A signed listing agreement or other signed written authorization from the owner or authorized person. The correct answer is option D. A signed listing agreement or other signed written authorization from the owner or authorized person. A licensee must have a signed listing agreement or other signed written authorization before advertising real property for sale or lease to the general public. Oral permission is not enough for this requirement. Buyer pre-approval and tax maps may be useful, but they do not authorize public advertising. Question 65. A deed gives Rowan possession for life, then ownership passes to Rowan Miller. What interest does Rowan Miller hold before Rowan's death? Option A, remainder interest. Option B, leasehold estate. Option C, easement in gross. Option D, mortgage lien. The correct answer is option A, remainder interest. A remainder interest is a future interest that becomes possessory after a life estate ends. A leasehold is a tenant's possession, an easement in gross is a use right, and a mortgage lien secures debt. The buyer's right follows the life tenant's measuring life. Question 66. An advertisement says a duplex is available only for adults with no children. What is the main fair housing concern? Option A. The ad forgot to mention the roof age. Option B. The statement indicates a preference or limitation based on familial status. Option C. The ad uses a list price instead of an appraised value. Option D. The ad includes the city name. The correct answer is option B. The statement indicates a preference or limitation based on familial status. Advertising cannot indicate a discriminatory preference or limitation based on familial status except where a valid housing for older persons exemption applies. Roof age, list price, and city name are not the fair housing issue in the wording. The problem is discouraging families with children. Question 67. Unless the parties' written agreement says otherwise, when should a Minnesota listing broker deposit earnest money after receiving it and final acceptance has occurred for Finley and Stillwater involving a farm parcel priced at $469,500? Option A. Only after the buyer's loan is fully underwritten. Option B. At any time before the deed is recorded. Option C. Within 3 business days of receipt or final acceptance, whichever is later. Option D. Within 30 calendar days after the first showing. The correct answer is option C. Within 3 business days of receipt or final acceptance, whichever is later. Minnesota trust account rules provide a default deadline of 3 business days after receipt or final acceptance, whichever is later, when the written agreement is silent. Waiting for underwriting, recording, or an arbitrary 30-day period would not meet that default rule. The parties can address timing in their written agreement. Question 68. A Stillwater listing agreement omits the real property description. What required element is missing? Option A. The buyer's credit score. Option B. The lender's underwriting model. Option C. The appraiser's license number. Option D. A description of the real property involved. The correct answer is option D. A description of the real property involved. Minnesota listing agreements must describe the real property involved. A buyer's credit score, underwriting model, or appraiser license number is not a required listing agreement element. The contract must identify the property being offered. Question 69. A seller accepts an offer only after the buyer receives financing approval. What type of clause is most likely involved for Avery and St. Paul involving a fourplex priced at $311,500? Option A, financing contingency. Option B, habendum clause. Option C, subordination clause. Option D, acceleration clause only. The correct answer is option A, financing contingency. A financing contingency makes performance depend on loan approval or financing terms. A habendum clause appears in deeds, subordination changes lien priority, and acceleration makes a debt due after default. The condition involves financing approval. Question 70. A listing contract says it may be cancelled only under certain stated conditions. Why does that matter for Taylor in Northfield involving a duplex priced at $345,000? Option A, cancellation terms are never allowed in listing agreements. Option B, Minnesota listing agreements must explain whether cancellation is allowed and the terms for cancellation. Option C, only the buyer may cancel a seller's listing. Option D, the broker can cancel only by recording a deed. The correct answer is option B. Minnesota listing agreements must explain whether cancellation is allowed and the terms for cancellation. Minnesota listing agreements must include a clear statement explaining if the agreement may be cancelled and the cancellation terms. The issue is contract clarity, not deed recording or buyer control. Stated cancellation terms help prevent disputes. Question 71. In a dual agency situation in Duluth, why must the licensee avoid advocating exclusively for one party? Option A, the broker becomes a government mediator. Option B, the buyer automatically becomes the broker's only client. Option C, the broker owes duties to both buyer and seller within the limits of dual agency. Option D, the seller's broker relationship disappears at acceptance. The correct answer is option C. The broker owes duties to both buyer and seller within the limits of dual agency. Dual agency means the broker owes duties to both sides and must work within those limits. The broker is not converted into a government mediator, and neither party becomes the only client. Acceptance of an offer does not eliminate the agency relationship or the disclosure limits. Question 72. What is the main purpose of an owner's title insurance policy for Sawyer Okafor? Option A, to insure the roof against storm damage. Option B, to guarantee future market appreciation. Option C, to replace the need for a purchase agreement. Option D, to protect against covered title defects that existed before the policy date. The correct answer is option D, to protect against covered title defects that existed before the policy date. Owner's title insurance protects against covered past title defects, liens, or ownership issues discovered after closing. It is not property casualty insurance, an appreciation guarantee, or a substitute for the purchase contract. Title insurance focuses on ownership risk, not physical damage or investment performance. Question 73. A lender offers Skylar Rivera a mortgage whose interest rate can change based on an index after an initial period. What type of loan is this? Option A, adjustable rate mortgage. Option B, package mortgage only. Option C, open-end listing. Option D, a graduated lease. The correct answer is option A, adjustable rate mortgage. An adjustable rate mortgage has an interest rate that may change according to an index and loan terms. A package mortgage includes personal property, an open-end listing is not a standard listing type, and a graduated lease changes rent over time. The index-based interest change identifies the loan type. Question 74. Regarding commission language in a Minnesota listing agreement, which statement best reflects the required consumer notice for Jordan and Red Wing involving a single-family home priced at $434,500? Option A. The state sets one mandatory commission rate for all residential listings. Option B. Compensation is determined between each individual broker and the broker's client. Option C. The MLS sets the minimum commission for every listing. Option D. The buyer must always pay the listing broker directly. The correct answer is option B. Compensation is determined between each individual broker and the broker's client. Minnesota listing agreements must include a notice that compensation is determined between the broker and the broker's client. The state and MLS do not set a universal commission rate for every transaction. Payment arrangements depend on the agreement and cannot be assumed from the listing alone. Question 75. A licensee directs families with children only toward one area of Bloomington. What fair housing problem does that conduct create? Option A, amortization. Option B, subordination. Option C, steering. Option D, novation. The correct answer is option C, steering. Steering occurs when a real estate professional guides prospects toward or away from areas based on a protected characteristic. Amortization is loan repayment, subordination is lien priority adjustment, and novation is contract substitution. The conduct described limits housing choice and raises fair housing risk. Question 76. A lender must disclose the cost of consumer credit so borrowers can compare loan terms. Which federal law is most directly involved for Sawyer in St. Cloud involving a fourplex priced at $256,500? Option A, Sherman Antitrust Act only. Option B, Clean Water Act only. Option C, Minnesota Torrens Act only. Option D, Truth in Lending Act. The correct answer is option D, Truth in Lending Act. Truth in lending requires disclosure of credit terms such as APR in many consumer loans. Antitrust, environmental, and Torrens land registration laws address different areas. The question focuses on loan cost disclosure. Question 77. A property manager collects rent for an owner in St. Paul. How should those funds generally be treated before proper disbursement? Option A, as trust funds handled according to the broker's trust account obligations. Option B, as the manager's personal operating funds. Option C, as sales tax collected for the state. Option D, as title insurance premiums. The correct answer is option A, as trust funds handled according to the broker's trust account obligations. Rent collected for an owner is money held for another and must be handled under trust accounting duties. It is not the manager's personal money, a sales tax fund, or a title insurance premium. Property management requires careful separation of client funds. Question 78. A lot has 140 front feet worth $220 per front foot. What is the indicated front foot value? Option A, $2,850. Option B, $30,800. Option C, $20,130. Option D, $775,000. The correct answer is option B, $30,800. Front foot valuation multiplies frontage by the price per front foot. Tax proration, commission, and income capitalization rely on other formulas. The question asks only for the land value indicated by frontage. Question 79. A licensee in Red Wing drafts a complex legal clause for Riley Garcia instead of recommending legal counsel. What risk is created? Option A, constructive eviction. Option B, of functional obsolescence. Option C, unauthorized practice of law. Option D, inverse condemnation. The correct answer is option C, unauthorized practice of law. Licensees may fill in approved forms and explain business terms, but drafting legal clauses can cross into unauthorized practice of law. Constructive eviction, functional obsolescence, and inverse condemnation describe different legal or valuation issues. Complex legal drafting should be handled by an attorney. Question 80. Under federal fair housing law, which group is a protected class in the sale or rental of housing for Schuyler in Winona involving a townhome priced at $201,000? Option A, credit score above 700. Option B, preference for lakefront homes. Option C, employment in real estate sales. Option D, familial status. The correct answer is option D, familial status. Familial status is a protected class under federal fair housing law. Credit score, housing preferences, and occupation in real estate are not protected classes by themselves. Housing decisions must avoid discrimination based on protected characteristics. Question 81. Which Minnesota tax is generally associated with recording a mortgage that secures debt on real property for Blair and Bemidji involving a vacant lot priced at $404,500? Option A, mortgage registry tax. Option B, personal income withholding tax. Option C, sales tax on furniture. Option D, special assessment appeal fee. The correct answer is option A, mortgage registry tax. Mortgage registry tax is tied to the recording of a mortgage securing debt. Personal income withholding, furniture sales tax, and assessment appeals are different issues. The exam often distinguishes mortgage registry tax from deed tax. Question 82. Why is the Minnesota agency disclosure form given to Kendall Thompson not enough by itself to create representation? Option A. It automatically creates dual agency for every transaction. Option B. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. Option C. It replaces all purchase agreement requirements. Option D. It gives the consumer a license to sell property. The correct answer is option B. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. The agency disclosure form informs consumers about relationship options but does not create representation. Representation requires a written contract such as a listing agreement or buyer representation contract. The other choices confuse disclosure with dual agency, purchase contracts, or licensing authority. Question 83. A buyer transfers contract rights to another buyer but remains liable unless released. What is this called for Finley and Stillwater involving a vacant lot priced at $364,000? Option A, novation with automatic release. Option B, this cheat. Option C, the assignment. Option D, ad valorem taxation. The correct answer is option C, assignment. Assignment transfers contractual rights to another party, but the assignor can remain liable unless a release or novation occurs. Is cheat and ad valorem taxation are unrelated. The distinction between assignment and novation is commonly tested. Question 84. Before negotiating a purchase involving a licensee's sibling as a principal, what should the licensee do for Quinn in Duluth involving a vacant lot priced at $352,500? Option A, say nothing because relatives are not licensees. Option B, disclose only after the commission is paid. Option C, ask the lender to disclose it instead. Option D, disclose the relationship in writing before negotiating or consummating the transaction. The correct answer is option D, disclose the relationship in writing before negotiating or consummating the transaction. Minnesota requires written disclosure when a principal is a licensee's relative or business associate. Waiting until after commission payment is too late, and the duty is not shifted to the lender. The rule protects parties from undisclosed conflicts of interest. Question 85. A Granite Realty branch office wants licensees to access current Minnesota statutes and rules electronically. Is electronic access acceptable? Option A. Yes, access to required statutes and rules may be made available electronically. Option B. No, only a paper binder signed by every buyer is allowed. Option C. Yes, but only if clients pay a records fee. Option D. No, statutes are never required in real estate offices. The correct answer is option A. Yes, access to required statutes and rules may be made available electronically. Minnesota standards allow access to required statutes and rules through an electronic agent. A paper-only rule, client fee requirement, or no access approach misstates the standard. The point is that licensees must have current legal resources available. Question 86. A $302,500 sale carries a 5% commission. What is the total commission before any split? Option A, $75,625. Option B, $15,125. Option C, $2,269. Option D, $4,084. The correct answer is option B, $15,125. Total commission is found by multiplying the sale price by the commission rate. Down payment, discount points, and property tax calculations use different bases. The phrase before any split means the full brokerage commission is calculated first. Question 87. Which deed gives Taylor Anderson the broadest set of title warranties from the grantor? Option A, quitclaim deed. Option B, bargain and sale deed with no covenants. Option C, general warranty deed. Option D, tax certificate only. The correct answer is option C, general warranty deed. A general warranty deed provides the strongest customary covenants of title from the grantor. A quitclaim deed conveys whatever interest the grantor has without warranties. A bargain and sale deed without covenants and a tax certificate provide less assurance than a general warranty deed. Question 88. A broker closes an existing trust account without notice. Why is that a problem under Minnesota trust account rules for Quinn in Duluth involving a condominium unit priced at $394,500? Option A, trust accounts may never be changed under any circumstances. Option B, only buyers can close brokerage trust accounts. Option C, trust accounts are optional for earnest money. Option D, a broker or closing agent must give written notice to the commissioner before closing an existing trust account. The correct answer is option D. A broker or closing agent must give written notice to the commissioner before closing an existing trust account. Minnesota rules require notice of trust account status changes and written notice before closing an existing account. This does not mean accounts can never change, but they must be properly reported. Buyers do not control brokerage trust accounts, and trust accounts are not optional when trust funds must be held. Question 89. A facilitator working with Sawyer in St. Paul performs services without representing either side. Which fiduciary duty generally remains unless expanded by written agreement? Option A, confidentiality. Option B, loyalty to the seller only. Option C, obedience to the buyer's investment goals. Option D, advocacy for the party paying the commission. The correct answer is option A, confidentiality. A facilitator does not act in a fiduciary capacity as a buyer's broker, seller's broker, or dual agent, but confidentiality remains a duty unless the relationship is expanded by written agreement. Loyalty, obedience, and advocacy belong to agency representation, not ordinary facilitator status. Commission payment does not create fiduciary representation by itself. Question 90. At Pine Ridge Realty, a salesperson asks which online system the Commerce Department uses for many licensing services such as applications, renewals, and transfers. Option A, MLS Grid. Option B, Pulse. Option C, Torrens Online. Option D, HUD Exchange. The correct answer is option B, Pulse. Pulse is the electronic licensing system used for many Minnesota Commerce Department licensing services. MLS systems, Torrens records, and HUD resources serve different purposes. Knowing the licensing portal helps distinguish administrative filing from transaction records and federal housing resources. Question 91. Which ownership estate gives Harper Patel the greatest bundle of rights with no stated end date or condition? Option A, estate at sufferance. Option B, life estate. Option C, fee simple absolute. Option D, license. The correct answer is option C, fee simple absolute. Fee simple absolute is the broadest ownership estate and can continue indefinitely. A life estate ends with a measuring life, an estate at sufferance arises from holdover possession, and a license is permission rather than an estate. The key phrase is ownership without a stated end date or condition. Question 92. When Schuyler, a licensee, intends to buy a client's property in Eagan, what disclosure is required before negotiation or consummation? Option A. The licensee may stay silent if paying full market value. Option B. The disclosure is needed only after the deed is recorded. Option C. Only the buyer's lender must be told about the license. Option D. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. The correct answer is option D. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. A Minnesota licensee who acquires or intends to acquire an interest in real property must disclose the license status and capacity before negotiation or consummation. Paying market value does not remove the conflict risk, and post-recording disclosure would be too late. Lender-only notice does not satisfy disclosure to the property owner. Question 93. Which appraisal approach is usually most persuasive for a typical owner-occupied home in a subdivision with many recent comparable sales for Kendall and Brainerd involving a newly built townhouse priced at $300,000? Option A, sales comparison approach. Option B, cost approach only. Option C, income approach only. Option D, a front foot method only. The correct answer is option A, sales comparison approach. The sales comparison approach is usually strongest when similar properties have sold recently in the same market. The cost approach can be useful for new or special purpose improvements, and the income approach is more relevant to income-producing property. Front foot analysis is a land valuation tool, not the main method for a typical home. Question 94. Which lease gives a tenant possession for a fixed term that ends automatically on the stated expiration date for Skylar in Winona involving a newly built townhouse priced at $271,000? Option A, tenancy at sufferance. Option B, the state for years. Option C, fee simple defeasible. Option D, easement appurtenant. The correct answer is option B, estate for years. An estate for years is a leasehold for a definite period and ends at the stated expiration. Tenancy at sufferance is holdover possession after lawful possession ends. Fee simple defeasible and easement appurtenant are not ordinary fixed-term leasehold estates. Question 95. A Woodbury buyer's loan has small monthly payments but one large final payment. What is that final payment called? Option A, prioration credit. Option B, replacement reserve. Option C, a balloon payment. Option D, equity dividend. The correct answer is option C, balloon payment. A balloon payment is a large unpaid balance due at the end of a loan term. A prioration credit divides expenses at closing, a replacement reserve funds future repairs, and an equity dividend is an investment return measure. The structure described is a financing feature. Question 96. During negotiations in Eden Prairie, Quinn Con changes the price and closing date in the seller's offer. What is the legal effect of that response? Option A, it is an acceptance because some terms stayed the same. Option B, it creates a lease instead of a purchase contract. Option C, it keeps the original offer open forever. Option D, it is a counteroffer that rejects the original offer and proposes new terms. The correct answer is option D. It is a counteroffer that rejects the original offer and proposes new terms. Changing material terms creates a counteroffer rather than an acceptance. The original offer is rejected unless the offeror renews or accepts the new terms. Keeping some terms unchanged does not preserve the original offer forever or convert the transaction into a lease. Question 97. A pooled interest-bearing trust account earns interest on client funds, unless otherwise agreed. Where is the interest generally paid under Minnesota rules for Drew and Edina involving a single-family home priced at $229,000? Option A, to the Minnesota Housing Finance Agency for the Housing Trust Fund account. Option B, to the salesperson as a bonus. Option C, to the listing client automatically. Option D, to the county assessor's operating budget. The correct answer is option A, to the Minnesota Housing Finance Agency for the Housing Trust Fund account. Minnesota rules direct interest from pooled trust accounts, less reasonable costs, to the Minnesota Housing Finance Agency for the Housing Trust Fund account unless the parties specify otherwise. The salesperson, listing client, and county assessor are not the default recipients. Trust account interest is regulated separately from commission. Question 98. A buyer's lender evaluates income, credit, and property value without discrimination. Which law commonly governs equal access to credit for Emerson in Bloomington involving a condominium unit priced at $220,000? Option A, Statute of Frauds. Option B, Equal Credit Opportunity Act. Option C, Truth in Zoning Act. Option D, Rule Against Perpetuities Only. The correct answer is option B, Equal Credit Opportunity Act. The Equal Credit Opportunity Act prohibits discrimination in credit transactions based on protected characteristics. The statute of frauds concerns enforceability of certain contracts, and zoning or perpetuity concepts are unrelated to lending equality. Financing decisions must focus on lawful underwriting factors. Question 99. Under Minnesota law, which statute is the primary source for real estate broker and salesperson regulation for Drew in Edina involving a lake cabin priced at $228,500? Option A, Minnesota Statutes Chapter 287 only. Option B, the Federal Internal Revenue Code only. Option C, Minnesota Statutes Chapter 82. Option D, a local MLS policy manual only. The correct answer is option C, Minnesota Statutes Chapter 82. Chapter 82 governs real estate brokers and salespersons in Minnesota. Chapter 287 covers deed tax and mortgage registry tax topics, and federal tax law or MLS policies do not replace state licensing law. Exam questions often test which authority controls licensing conduct. Question 100. In appraisal, what does highest and best use require for Reese in Mankato involving a mixed-use property priced at $232,500? Option A, the use that produces the highest commission. Option B, the use preferred by the current tenant only. Option C, the use with the lowest property tax bill. Option D, a use that is legally permissible, physically possible, financially feasible, and maximally productive. The correct answer is option D, a use that is legally permissible, physically possible, financially feasible, and maximally productive. Highest and best use considers legal, physical, financial, and productivity tests. Commission, tenant preference, and tax savings alone do not determine highest and best use. The concept focuses on the most supportable use of the property as real estate.